The distinction needs to be made between data protection, we know what that is, we know how that works, and privacy, we know what that is, we know how that works. Data privacy just doesn't help in this context. It muddies the water. It may make sense in other places, but here in the UK, we know what we're talking about on both sides.
Okay, January 28th. Happy what? What do we celebrate? This is the problem. So today we have a special episode in which we're asking a few past and upcoming guests to share their thoughts on the difference between data protection and privacy, or, if they dare, the purely American and more recently coined concept of data privacy. We've got Carissa Véliz, Associate Professor in Philosophy at the Institute for Ethics in AI and a Fellow at Hertford College at the University of Oxford. We've got Gabriela Zanfir-Fortuna, the US-based Vice President for Global Privacy for the Future of Privacy Forum, who will give us a very forward-looking perspective with the age of AI in mind. What else? We've got Quinn, a qualified lawyer both in Ireland and New York, author of the Data Protection Implementation Guide, who, like Carissa and Gabriela, has also been here with us already. We've got Markus Wünschelbaum, advisor to the Hamburg Data Protection Authority in Germany, and we have Tim Turner, a highly experienced data protection trainer and consultant who's worked as a DPO in the public sector and even for the ICO, giving us that UK perspective. I've aimed to take the least of their time by simply asking them for a pre-recorded statement on their point of view. So this is going to be brief. But before we listen to them, a few words on why we're doing this. What's the point? There has been some animosity in the EU and the UK towards some people celebrating a data privacy day instead of a personal data protection day or International Data Protection Day. As it often happens, where there is a feeling that American influence is going too far, in this case, especially sensitive since the whole thing started in Europe, and it's even a US-based privacy association, the IAPP, that is now mostly taking over the industry events, certifications, pushing US vendors like OneTrust and others, and pretty much cutting through, as we've seen happen in many other sectors before, cutting through the typically highly fragmented local markets for DPO accreditations, data protection events, pushing English as a language. I mean, we know the story. It's happened across so many verticals. And look, I'm surely contributing to the problem, right? I'm teaching some of the IAPP courses. I attend many of the events. I do some summaries here, so I can't complain. And this is called Master of Privacy, not Masters of Data Protection. But the perception remains, and it makes a lot of sense, that American influence is just disproportionate, particularly in an area that is so close to European identity. Look, even e-privacy consent pop-ups are run by US companies and hosted in the US, which would have sounded like a joke in Brussels back in 2016, right? So well done to all those software service companies. But yeah, it is quite paradoxical. So that goes for the negative reactions to people celebrating Data Privacy Day instead of Data Protection Day. Now, as many of you know, January 28th started as a celebration of the anniversary of Convention 108. So the Convention for the Protection of Individuals with regard to automatic processing of personal data, signed in 1981 by members of the Council of Europe, which, as you also know, is not related to the European Union. And it's in fact older, with many more members, right? And 55 countries from Europe, Latin America, or Africa signed that convention. So it was in 2006 that the Council of Europe decided to celebrate its anniversary, right? That date. So the International Data Protection Day. Then, in 2009, with the Obama presidency just started, the US Congress adopted a resolution to celebrate a Data Privacy Day on the same date. In any case, I do want to add some thoughts at the end to do some justice to this concept of data privacy in the US. But now, let's listen to our experts. We start with Carissa Véliz, again from University of Oxford, for a more philosophical point of view.
Privacy is the quality of having your personal information and your personal sensorial space unaccessed. That is, you have privacy with respect to another person to the degree that the other person has not accessed your personal information and your personal space, to the extent that they don't know anything personal about you and that they cannot see, smell, touch, or hear you, in contexts in which people have reason not to want others' attention. Data protection is a tool that we use to safeguard privacy. And one of the many limits of data protection as a legal tool is that it focuses only on information, whereas privacy has to do with information, but it goes above and beyond information. And the right to privacy is the moral claim that we have against others, that our privacy be respected.
Here's now Markus Wünschelbaum, again, policy advisor at the Hamburg Data Protection Authority.
I think of privacy as a fundamental right. It exists on its own before any ordinary laws, and data protection is just our current framework to protect it. But the transparency-focused approach of data protection, especially with the GDPR making everything visible to control it, is actually changing how we see privacy itself. We're turning a basic human need into something we manage with checklists and processes. And I mean, if you look at privacy by design, it's meant to be central to data protection. But since it's harder to implement than checking boxes, it often gets pushed aside. And we end up focusing on what we can easily document rather than what has the most potential to serve privacy. So while the GDPR's approach is just one way to protect privacy, shaped by our times, and privacy remains a constant, it's not untouched by the data protection frameworks we build around it.
Okay, Tim Turner, data protection trainer and consultant.
Here in the UK, we have two distinct things, and things that are common to countries in the European Union and in Europe generally as well. We have data protection, which is a system of principles, rights and obligations that apply to the use of personal data, which itself is defined in the UK GDPR, which is of course derived from the European GDPR. And then we have the Human Rights Act, which it's as there's a relationship here. Human Rights Act derived from the European Convention on Human Rights, to which the UK is a signatory. And one of the rights that's laid out there is the right to respect for a person, the privacy of a person's home, family life and correspondence. So we have a legal system, a legal mechanism that applies to the use of personal data. And then we have a separate right that applies to the protection of the right to respect for privacy, which applies to a wide range of situations, some of which concern personal data or data about people and data that relates to private situations, but some of it doesn't. Some of it's about the privacy of the body, the privacy of places. So there is some overlap between the two things, but they are distinct and crucially, they are defined. They're not the same thing as each other, but they have a close relationship. Data privacy, on the other hand, is something. I don't know what it is. It's not defined anywhere. There's no single recognizable definition of what data privacy is. It means different things in different places, and it doesn't satisfactorily capture the system that we have here, because data privacy implies that you're only looking at information, personal information, which is private. And of course, data protection doesn't just apply to information which is private, it applies to all personal data. Whereas privacy doesn't just apply to data. So I insist, for my purposes at the very least, and I'm sure it irritates lots of other people, I think the distinction needs to be made between data protection, we know what that is, we know how that works, and privacy, we know what that is, we know how that works. Data privacy just doesn't help in this context. It muddies the water. It may make sense in other places, but here in the UK, we know what we're talking about on both sides.
Here's Brendan Quinn, again, qualified lawyer both in Ireland and New York.
On the difference between data protection and privacy, Data protection and privacy are closely connected and complementary rights. While the terms are frequently used interchangeably by data protection and privacy professionals, the rights are separate and offer different protections under the EU Charter, and both freedoms can be restricted in accordance with Article 52 of the Charter, and Article 23 of the GDPR allows restrictions on some of the rights of the data subject to data protection. Privacy in the EU Charter creates the right to respect for an individual's private and family life, home and communication, which creates 4 rights and is more specific than the right to data protection, which only applies when data is processed.
And last but not least, here's Gabriela Zanfir-Fortuna, Vice President for Global Privacy for the Future of Privacy Forum.
The value of data protection as a legal field should become increasingly more visible as the AI revolution advances. What is at the core of data protection, if you think about it? Transparency about how data is used, by whom and why, tools for people to be able to have a say about how their data is used, to exert ultimately their free will, their autonomy related to information about them. Well, these are increasingly important with the development of a technology that is designed to be at the receiving end of offloading cognitive ability and supporting decision-making. Data protection has a 50 years or so history in offering such safeguards for people and their rights when it comes to data, bits and numbers, codifying information about them, while, and this is very important, at the same time allowing and supporting technological development. The question is how these core data protection tenets can evolve so that they are best suited for the age of AI.
Okay, I said I would add a few words from the US perspective. And there's plenty to be said about the specific developments of a US common law in its departure from English common law when it comes to privacy torts, right? To the 4 privacy torts, like intrusion upon seclusion, public disclosure, false light, appropriation. Beyond that, there is a connection between privacy and the 4th Amendment in the Constitution, right? With regards to the protection against searches without a warrant, for example. But that, again, that's a right that is associated to being a citizen. It's in the Constitution. It's not a fundamental human right. And expectations are more closely related to the EU's separate right to privacy, again, with that caveat. But not to data protection, as it is differentiated, as Brendan was saying, in the Charter, right? So closer to Article 7 than to Article 8, to the respect for privacy and family life. But what do we do with data protection in the US? And the way I normally explain, in fact, personal data protection to Americans is that whereas privacy deals with the present and is closely tied to confidentiality or to being left alone, as it originally started in that famous article, right? So communications, private spaces, and so on. Data protection is about the future. It's about the consequences that you cannot even foresee. Your freedom one day, your life one day, the impact of you becoming more predictable, or your children being denied insurance or a visa because of certain pictures or comments, even though those details were published in a website for everyone to see and index or store or dump into an AI model's training dataset. So, in a way, data protection is closer to the Fair Information Practice Principles, FIPS, from the 70s, access, accountability, purpose limitation, transparency, which have strong roots in the US and would go on to influence the OECD principles and eventually even the GDPR, right, in Article 5. Something that Elizabeth Renieris, who's also been here in the program, covered in her brilliant book, Beyond Data. And it is my understanding that by referring to data privacy, the US House first, and then the Senate back in 2009, were trying to accommodate this newer term, more closely related to processing data at scale by automated means. This is also why the new version of the EU-US Privacy Shield, that for now has solved data transfers to the US after Schrems 2, is actually called the Data Privacy Framework. As a last note, I'll add that There is a final twist to this in Spain, in case anyone cares, where the direct translation of privacy is really an alien concept when it comes to our legal system. I'm not going to bore you with it now, but if anyone is really curious about Latin etymology, Roman roots, and that separate discussion on how these rights evolved, we're also releasing a separate episode in the Spanish channel today covering the differences and overlaps with the great Borja Suara, a well-known lawyer and public figure in Spain. And I know that was a lot. Happy International Data Protection Day if you are in one of the 47 member states of the Council of Europe, or even those that signed Convention 108, like Argentina, Morocco, Mexico, or Senegal, for example. Happy Data Privacy Day if you're in North America or Australia. And Australia is coming up in the program very soon, by the way. And happy International Privacy Protection Day if that kind of blend is your thing, which is what some countries have chosen to follow. And all your comments and contributions to this debate are very welcome on our Spotify, LinkedIn, or YouTube channels. The links are in the show notes. Thank you. Okay, that's all for today. Follow us on Blue Sky, and in the Masters of Privacy Altogether profile, you will find the starter pack, which includes the feeds of all of our past guests. There is also a Masters of Privacy LinkedIn channel, which I invite you to follow, where you will find links to our transcripts, cheat sheets, and other surprises every now and then. Our main website is mastersofprivacy.com. Thank you for listening.